Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 22-1057. Keezio Group LLC, doing business as Keezio Group petitioner versus Consumer Product Safety Commission. Mr. Godding for the petitioner, Ms. Mundell for the respondent.
Morning, counsel.
Good morning, Your Honors. May it please the court, I'll reserve 3 minutes for rebuttal. As indicated by the administrative record, CPSC never addressed substantial evidence that subjecting aftermarket mattresses to the same thickness restrictions as OEM mattresses, including the 1-inch limitation on foam, that caregivers would find the aftermarket mattresses be just as uncomfortable as the OEM versions and would revert back to using more risky, soft bedding to increase comfort levels.
Could we start talking about the
Sure.
interesting 28J letters we got?
Yes.
Yes.
Absolutely.
Right before argument. In particular, at least I have the question, if the commission were to adopt the ASTM standard, which as I understand it is for original manufacturers, to extend it to aftermarket manufacturers as well, would that be the end of your objection, the end of this case, or do you argue for more than 2 inches, or are there other aspects?
Yes, the amended version, if they adopted that, would allow for a 2-inch max thickness, and there's no limitation on foam. Now, as a practical matter, you can never get to quite 2 inches of foam, but it would allow manufacturers like my client to increase the foam to the point where perhaps it is going to be more comfortable for the user. So yes, the answer to your question is that would probably do it for our client.
Okay. And if they decline to adopt it, as I understand it from the statute, then they can just retain their existing rule. Would this case then go forward, or in the process of them explaining why they're not adopting and retaining the existing rule, they actually do more than retain and actually change or create a enhanced record?
Yeah, it's not
a decision
clear.
Such that I'm just trying to figure out if it's a whole new administrative case or if just a supplemental briefing would be all that would be required if they don't accept.
It's my understanding on how CPSC has done this in the past. The staff will issue a briefing package to the commission, so it'll look like the briefing package that we have in this case, and then in short order, CPSC then makes a decision. The decision that the commission makes may be very short. It could be just a page. But you would have the briefing package, which would become part of the administrative record. Our position would be that if the original rule is retained, that the administrative record that we're dealing with here today could still be relevant, but the administrative record may be amended or enhanced or whatever you want to say based on at least that briefing package.
Right.
Based on what, I'm sorry?
The briefing package. So
okay.
Yeah.
But does that thinking in administrative law context, does that addition of a whole new record or a partial record then create a whole new case, or would this case continue?
I would say this case continues because if let's say they reject the rule, the new one, or not the rule, the new ASTM standard for reasons that we don't care about, we still need to have an opportunity to challenge the rule that's still on the books. So the original case would still be live, I think.
Okay.
But the record will have been supplemented.
Yeah, you could. That's the way you could look at it. Yeah.
So there may require new briefing if you were to go forward.
Yes. So yes, there would need to be something submitted to the court.
And would normally when there's an existing standard that's been adopted, because they had already adopted the ASTM standard for original manufacturers mattresses, then they do nothing. Obviously, if they agree with it, it becomes part of that rule automatically, and if they do nothing, it becomes part of that original manufacturer rule automatically. Does the same thing apply? Because the rule before us is an aftermarket manufacturer's rule that I get incorporated one, but I'm trying to figure out how much hopscotching happens under the statute. Is there anything automatic? Say they don't act, they do nothing for.
Yeah, if I understand your question, and tell me if I didn't. So 16 CFR 1221.2 incorporates by reference that ASTM standard that was just amended. And F2933-21, which is part of the rule that we're challenging, incorporates by reference F406. So it's a little confusing, but they get there. So even though F406, which was just amended by ASTM, technically it was intended to apply to only original OEM mattresses, it ultimately, because of the way everything's set up, it will apply to aftermarket. Well,
is that true? Because the rule here repeatedly states, obviously before this happened, but repeatedly states that changes to, I got F406 if I have that right, are outside the scope of the aftermarket. And so it seems like they've already said changes there. This is its own world.
Yeah, if you were to ask me that question, I was prepared to answer it. I actually disagree with what the preamble says. They're all part of the same ball of wax. But
the rule itself, I'm just, But what I'm trying to figure out is, I understand your sort of record argument, but just the legal argument under the statute, which prescribes consequences when an adopted standard is modified. How would that happen? Because when a rule is incorporating another standard for a different context, and in doing so, it says changes to that original standard will not affect this rule.
Yeah, again, I disagree with that that thought, but the way this works is that F406 has been on the books forever, since 2013, I think, right? Because of 16 CFR 1222.2. It just governs mattresses. It doesn't talk about OEMs. It doesn't talk about aftermarket. It just governs mattresses. And so what CPSC and ASTM have done is they've set up a new voluntary standard, F2933, which refers to F406, and F2933 applies specifically to aftermarket mattresses. So they do get there. So it does work. Does that answer your question?
Yeah, I'm trying to sort it. It could be simpler, but it doesn't seem to be in this case.
Yeah, there's a footnote in our brief that kind of walks you through that.
Well, let me ask, under the existing rationale for the 1.5, and then the fact that we're now looking at a 2-inch thick mattress, doesn't the rationale also have to be revised to match up to the 2 inches when you go through this process?
So, yes, in the amended 406, there doesn't seem to be there is no rationale. It doesn't say this is why we're doing it. But as a practical matter, that is why it's our understanding ASTM was looking at this, because they are worried about that perverse incentive. And so now we have, and this is really important, we have no limit on the foam, because under the standard that we challenge, there's a 1-inch foam limitation. And that applies to both the OEMs and the aftermarket. But with the new rule, a manufacturer can get kind of close to 2 inches of foam, depending on if there's a backboard and other things, but certainly a lot thicker and more comfortable than what we're dealing with here.
So what is your suggestion about the posture of the case at this point in time, now that we do have the recent activity in the case?
So we agreed with counsel that, it's only 3 months. They have 90 days to do this. And it's my understanding they usually get that done. So we're willing to hold the case in abeyance to see what happens. that doesn't moot our case because our argument was they should have waited for ASTM and not promulgated a rule. And it's our position that the rule that's on the books now is actually more dangerous to infants than the status quo before the rule was adopted. And
But is there any scenario that waiting the 90 days and holding this in abeyance and going with the 2-inch, that it moots the case at all? Like, do you have any sense of agreement that if everything works out, that the case is over, or do you still want us to rule on this?
Yeah. What's happened is we are willing to hold this in abeyance to see what CPSC does. I was just making the point, maybe I should have stopped, is just that what has happened so far doesn't change this case. You could move forward with the case, and we would ask that you vacate the rule, the reasons we've stated in our briefs. But because there's such a short period between now and when CPSC makes a decision, we're willing to cooperate and hold in abeyance.
But to follow up on Judge Child's question, if they adopt, I want to make certain on this, if, and it's a big if, CPSC adopts the rule and in doing so makes clear that it also applies to aftermarket mattresses, then your case would be mooted. Your challenge would be mooted.
But yes, probably.
I just had one more factual question because you just referenced it. Because I know when you had the 1.5-inch mattresses, there's the 1-inch limit on the foam, and there's discussion in the record about, and I'm not going to have the right word, did you call it backboard or underboard or supporting board that's part of the mattresses? Is that just for original manufacturers, or is that also for replacement mattresses?
No, it would. So what the rule as written now says is if the OEM has a backboard, your mattress, your aftermarket mattress that is replacing that one also has to have basically the same backboard. And that's that 1/2 inch between the 1-inch foam.
You said basically the same.
It can be the same or larger, the backboard.
Okay. It can't be less. Can't be smaller?
It cannot be smaller.
Okay. And that takes a 1/2 inch.
Well, that's where you use that extra 1/2 inch.
So, no, I'm trying to understand because you said now there's not a limit on foam.
Oh, you're talking.
The max now on foam would be 1.5 because you need another 1/2 inch for the back.
It's going to work a little differently between the one we have now and the new standard. So as the standard exists now, you can have, in theory, up to 1 inch of foam, and practically you can't, but up to 1 inch of foam, the OEM can. And then they have another 1/2 inch because of the 1.5 max. And that is basically that could be the board. So now
it's part of the mattress itself.
And it's part of the mattress itself. Okay. And so the rule is if I'm making an aftermarket mattress and my mattress is intended to replace an OEM that has a floorboard, my aftermarket mattress has to have a floorboard that is the same size or larger.
Got it. Okay.
Yep.
If there are no further questions, you will from the government now.
Turn it over.
Morning, Your Honors. May it please the Court, Amanda Mundell on behalf of the Commission. I'm happy to address the 28J letter if the Court has questions on that. We agree with counsel, at least in the posture that the case is in right now. The clock, once the Commission receives formal notice from ASTM of that revised standard, is going to start to run for the Commission to review whether to adopt the standard that includes this 2-inch increase or not.
And that 90 days is a hard deadline. There's no opportunity for extensions whatsoever.
That's my understanding, Your Honor. They complete that review in 90 days and either let the ASTM know, or if the 90 days lapses without them getting back to ASTM, then the standard would just be incorporated into the code after 180 days.
And then, so it would be incorporated into the rule for original manufacturers.
That's right, Your Honor. And
would it, as a matter of law, be incorporated into this rule, which incorporates, well, says you got to meet the same standard as original manufacturers, but at the same time says changes to that original manufacturer rule are not relevant to what we're doing here.
Yeah, so I
It's kind
think
of going
there's,
in two directions.
yeah, I think there's two different questions of scope there. We agree under the statute that as this operates, the change to F406, because it is incorporated by reference into the standard at issue for aftermarket mattresses in this case, would then be incorporated into the code. The comments in the preamble about what was going on with the ASTM working group on 406 and that being outside of the scope of this rulemaking was just to note that the calls to put a pause on this rulemaking for aftermarket mattresses simply because there's a task force for OEM mattresses working to figure out whether to change those requirements are outside the scope in the sense that we have this whole pool of unregulated aftermarket mattresses, and so figuring out how to regulate those doesn't necessarily require the agency to wait for the F406 OEM mattress group to finish their work. But we agree as a matter of law under the statute, changes to this revised standard, if they're accepted by the commission or if they become part of the code just by operation of law, that will impact the standard at issue in this case.
Are you prepared to defend your current rule if the new standard is not adopted?
Your Honor, I don't want to prejudge, the additional work that the commission is going to do, but certainly, at least based on the record that the commission had at the time of this rulemaking, we do believe that this rule is reasonable. It's not arbitrary or capricious because it incorporated a long-standing standard on the thickness of mattresses that have been demonstrably safe. Now, we recognize that there's some amount of uncertainty out there to determine what incremental increases in mattress thickness may exacerbate a risk of gap entrapment on the one hand or play into the use of soft bedding on the other. But what we do know is that this 1.5-inch limit is safe. So when it comes time for the commission to make cautious decisions about children and their safety, adopting a standard that we know is safe now is eminently reasonable. And there's really no support in the record for Keezio's suggestion that this standard is suddenly going to increase the use of soft bedding or increase suffocation-related injuries. Again, there's some unknowns there, but we do know that parents and caregivers use soft bedding in a variety of environments. So that's a long problem with more complicated solutions. And this issue, with respect to the thickness of aftermarket mattresses, is still reasonably tied to that 1.5-inch safe limit.
Do you, so normally if an agency makes a decision and then there's a development in the record that they then create new record materials on, that would be the end of this case, the existing case on the old record, and would be mooted out and people would just have to bring a new challenge altogether to the new agency decision, even if that's adding old record and new record together. Does the Justice Department have a position on whether, if the CPSC decides to retain this existing rule that's challenged here, but would only do so after having an added, either a new record or a supplemented record based on its analysis of this new ASTM standard? Whether that means, regardless, this case is moot. It's going to be moot because the agency now has a new matter under consideration, and it will either moot the case because it'll do what they want, or it will moot this case because it'll be a whole new case with a new record. Or do we keep this? I'm sorry, it's long to say this. Or is it just because it's just being retained? Is this just sort of a supplemental thing that we would just keep the case here and have supplemental briefing, even though it's actually a new agency record?
Yeah, Your Honor, I think it's an unusual situation, and we don't have a position whether the court ought to dismiss this case as moot and then, take it up, I assume, if it's not in the petitioner's favor, upon a new challenge on the record, or whether this would just get retained by the panel with supplemental briefing. I think the fact that if the agency were to retain the original standard, and as a practical matter, it's almost as if you would just be reviewing the record with some supplemental record material and supplemental briefing, but we don't have a position on whether the court should do one or the other.
Well, it's almost has some jurisdictional consequences, because if it's upon the advent of this new ASTM standard, which no one disputes, whatever decision CPSC makes is going to apply actually to this very same rule in these aftermarket ones. So we'll either make them happy and be moot, or it'll be a whole new decision with a whole new record. And it needs to be challenged in its own right. And so that would make this current appeal or current petition for review moot as well.
Yeah, you're right. That may well be the case. And I don't know if there's a possibility for the petitioner here to amend the petition for review to add this additional decision. But, I think either way, certainly the case that if the commission were to just adopt the standard, we agree with counsel that probably moots the case. And then if they don't adopt the standard, if the court dismisses it, we certainly wouldn't oppose the court dismissing the case and then having this new, petition for review brought to the agency's final decision, which, uses that new record plus the existing administrative record that we have here, which we agree is certainly relevant.
Well, normally what happens when agencies supplement decisions is you have to file a second petition for review from that second agency decision. We get this at least in FERC cases all the time. Is it your position or the government's position that they will have to file a new petition for review to challenge, if they want to challenge if there's an adverse decision in their view from the CPSC? Do they have to file a new petition for review, or can this existing one encompass it?
Your Honor, we don't have a position on that. I think just the tricky thing about this is that if the commission just decides to retain the existing standard, it's true that that's final agency action, but it's really no different than enacting.
It's a new record. It's got a different record.
That's true, and we do think that supplementing the administrative record with whatever staff briefing package exists would be appropriate there. But we don't have a position on whether the court should require a new petition for review. We certainly wouldn't oppose that. But I do think it's tricky, just given the retaining the same.
Retain is a different verb, yes.
Let me ask you this: if the commission does nothing, I gather it's common ground that the change in the standard will apply to aftermarket mattresses through a process. If the commission rejects that change, will there be further notice and comment before they, if they want to reject it, will there be further notice and comment before they take that action, or will they propose to do so and then receive comment?
Your Honor, I think the agency could do that. Usually how this works, because the 90-day period is so short, I think the agency typically notifies the public of the commission's vote. But I don't know that there's really a mechanism in place that every time something like this happens, there's a limited period of comment, maybe something like 14 days. But the 90-day period is so short that I wouldn't expect there to be, the typical type of notice and comment period you would see in an original rulemaking.
Well, the petitioner has raised certain objections to the existing decision based on the claiming a lack of support in the record. And some of those, or at least one, might be readily addressed if the commission were to reopen the record with respect to addressing that and perhaps allowing further comment. There's also a question as to whether one of the petitioner's objections has been forfeited by reason of being raised belatedly. And that could then be cured and raised initially if there were new rounds of comment. So I'm wondering whether the case wouldn't be a lot cleaner if this version of it went away and a new version based on a new record were available for the petitioner to challenge if he wants to.
Well, I think that's right, Your Honor. I think the development of a staff briefing package assessing whether or not to retain an existing standard or adopt this 2-inch limitation is going to address some of the concerns that petitioners raised here. But we don't think, based on the existing record, those concerns amount to arbitrary and capricious agency action.
Well, if it just becomes the standard I'm sorry, you're saying if it doesn't adopt it, then they will give us a decision, make a reasoned decision?
I'm sorry, I understand that.
The commission would then issue another, hopefully reasoned decision as to why it is not adopting the standard.
That's right, Your Honor, and that would not
be limited to the reasons given for in the current record.
That's correct. And of course, as you may know, some of the data in the existing administrative record runs to April 2021. So with this now revised standard coming out here at the end of 2022, there's an additional 1.5 years of incident data potentially available to the commission, as well as other modeling or other tests that they can do to assess whether this standard improves safety or not.
Well, the whole dispute would be ill-served if it comes back on the same record.
We agree, Your Honor. So if the commission, let's say the commission rejects the revised standard and issues a staff briefing package explaining why, and petitioners here continue to wish to challenge that rejection and the maintenance of the existing standard, then we do agree that we would at least at a minimum want to supplement the administrative record with that new staff briefing package. Or
And
whatever.
is there some limitation on what can go into that new record? I mean, the staff puts together a package, presents it to the commissioners for a vote, right? And if the commissioners accept that package, are they constrained from adding anything additional to that? I mean, if the package doesn't address the issues that are raised in this case, then we're back where we started.
Well, I think whatever, the package will be tailored to the decision to keep or not keep the existing standard, which as a practical matter would probably address most of the issues in this case. But we think that, if the court were to review the agency's decision to retain the existing standard, that decision would necessarily bring in the data and other, record material the agency relied on to develop that rule to begin with, in addition to whatever new facts or data or information the agency relied on at the time it issues that staff briefing package.
Why is this change happening now?
It's a good question, Your Honor. It's a little inconvenient to happen so close to oral argument. But my understanding is that the ASTM working group, along with the commission, has long been trying to assess whether there's a need for safety or whether, the expansion of the thickness of mattresses is appropriate. These things take time. And the fact that it's happened now is more just a dint of that process playing out over time than I think anything else. But we regret that this happened, circumstantially right before argument. I know that made it a little bit more challenging.
Here's just to follow up on Judge Ginsburg's question. There's an argument in your brief that going from 1.5 to 2 inches, again, before this ASTM came out, would not be substantially similar or more stringent, more protective than the existing standard. And so it's not something that they could have, in our prior world, have even adopted and considered. That at least there's some question whether that was raised by the agency itself. Is that the type of thing that would be on the plate for this next round, or is it, as you said, just put a yay or nay on whether we want this new standard?
Well, I think because, assuming this court doesn't vacate the rule before the agency makes its 90-day determination, because that's on the books, it's under that framework of whether the increase to 2 inches improves safety. So I think it is a slightly different inquiry. And so there's less of a question about whether that's making it more stringent and just a question of whether it improves safety.
And then I just had one more question. If the agency, because there's 3 doors here, and one is that the agency does nothing. If the agency does nothing, does the briefing package from staff still become a part of the record, or does it only become a part of record if the agency makes an affirmative decision one way or the other?
Your Honor, I'm actually not aware if a staff briefing package is prepared if the agency does nothing. Perhaps that's the case. But I think as a practical matter, the supporting data and materials become a part of the record when there's an agency decision, final agency action. I think if the agency just sits by and does nothing, there's really not the same affirmative decision where the agency votes to accept or votes to reject the rule.
Okay. Thank you very much.
Thanks for your time, Your Honors.
We'd like to hear from Mr. Gunning.
Yes, Mr. Gunning, we'll give you, you said 3 minutes for rebuttal.
Just to go back, so it's my understanding there's no notice of comment if they just allow the existing rule to stand, and so we wouldn't have a chance to go through that formal process. My understanding, is that all the commission does is issues like a 1 or 2 page, yes, we're just going to keep the new standard. Here was the vote. Sometimes the commissioner will make a statement, but there's no preamble. There's nothing for us to look at and say, here was the commission's, not the staff's, the commission's rationale. And so that, in that sense, it is not like a new case. So that's the first point. The second point was,
Excuse me, what's that?
Go ahead.
Well, is that what happened so far?
That's what's happened in recent rulemakings where ASTM has amended a voluntary standard and then they went through this process. And so the second point I want to reiterate is that, and this is in the record right now, the reason why the commission doesn't like this new rule has nothing to do with the 2-inch or the...
Wait. How do we know the commission doesn't like this new ASTM standard?
Because they said we are not going to wait on ASTM.
Well, that's a very different point than saying we don't like something that they get rid of it. I think that's getting into things.
They have indicated that the rule that has now been adopted by ASTM, they don't like the measurement, the way the measurement protocol for measuring the gap between the mattress.
This is the so-called methodological dispute?
Yeah, it's the protocol. How do you do that? That isn't our case. So if this is truly an up or down vote, the commission, and they reject this new rule or the new standard, it may be for reasons completely independent of why we challenge this rule. And so then that means the only way we can continue challenging the rule is on the administrative record that we have now.
Well, what about the staff briefing package?
Well, let's say the staff briefing package doesn't address, it just accepts the 2 inches. It doesn't have a problem with it and recommends to the commission that you should reject this new rule because the measurement protocol isn't working for us. That's not our case. So my client still needs to have an opportunity to come back to this court and argue, assuming on the administrative record that exists now. So it's not you're asking great questions, but it could be a situation where my client has no option for judicial review.
And you said there might not be notice and comment in the ordinary sense, but I assume your client and others in the public who want are free to send in letters.
We could, and then the commission would have to.
They accept public communication during this time period.
And then they would have to decide whether or not it goes into this it goes into an administrative record. Yes.
Well, I mean, if you send the communication, it becomes part of, if not the administrative record, part of what you will bring into court.
Usually it does.
But so let me ask you, why aren't your interests better served by withdrawing this case, deciding that it's moot, so that there's no doubt that there's later final agency action that you can challenge, and so that an issue that you've raised in what may be a belated and forfeited fashion here, namely the substantially same issue, can be raised before the commission clearly?
We could, but I guess I don't know what the commission's going to do. And based on the example I just gave, I would be reluctant to do that. I guess we could resubmit everything, but again, it's not a typical rulemaking proceeding. There's no preamble. There's no notice and comment.
But there's a final agency action.
It would be final agency
and a new
action.
record.
That's true. Yes. I guess at a minimum, I would ask, if you're going to hold this in abeyance, is that we be able to brief that issue if they do reject the standard.
Which issue?
The issue we're discussing, whether or not this administrative record continues or if it's a new case.
Well, I guess another way to think about it is, if this is all hypothesizing, if they reject this new standard and have not just methodological, but also safety concerns, which is voiced in this case, and have a thick staff briefing package. You want to brief a challenge to the CPSC decision in a little old supplemental brief, or would you want to have a chance to do a full-fledged briefing and reply brief to tackle everything combined now that you would find that you disagree with in that decision?
I guess the way I look at it is, if the CPSC were to address the 2-inch and address our issues, which is what we want them to do. I mean, that's the whole point of the lawsuit. It may, as a practical matter, moot the current administrative.
No, I'm saying if they rule again, they don't adopt the standard.
Oh, yeah, if they don't adopt the standard. But the CPSC has addressed our issues. Let's say they don't adopt the standard. They say we don't like the 2-inch max. And they address that, which is the point of our lawsuit. We want them to address all of this evidence that they didn't consider. Then that kind of moots the current administrative record, but I don't think it means this administrative record is now gone.
So if they say some more things, and again, but if they just say some more things, give a more elaborate explanation that responds line by line to your brief,
right,
and stick with 1.5 inches, your client's done and not going to challenge that next decision?
No, we could, but it would probably be on that new briefing back.
That's what I'm asking. And then would you want to do that in supplemental briefing, which tends to be very short and doesn't include reply briefs? Or at that point, that's what I'm saying is at that point, you're going to have both this original record and maybe some of it will have gone away or not. Maybe some will go away and some won't, and some new ones will come along. If we treat this as this case just continuing, all you get is a little supplemental brief.
Right.
And at that point, you're going to have sort of 2 records to grapple with. And who knows, maybe they'll say all kinds of new stuff that you disagree with as well.
Right.
And it's a lot to not do that through normal briefing on a new petition.
It's a good point. I did not think about that, but it is so difficult for me to sit here because I don't know how this is going to play out.
Sure.
I just don't. And I can't give up on the current administrative record. I can't do that right now. And so I guess I would probably file a motion with the court to ask for extra pages and to brief this issue, which is it's an interesting issue and it's a good question.
Thank you very much for your time. The case is submitted. You can get ready, but we're just going to pause for a minute until Judge Ginsburg returns. Mr. Petrocelli?
Case number 22-5080 et al. Steven M. Greenbaum, on behalf of himself individually and as administrator of the estate of Judy Shoshana Lillian Greenbaum, deceased et al., appellants, versus Islamic Republic of Iran et al. Mr. Petrocelli for the appellants, Mr. Hudat for the intervener appellate, United States of America.
Good morning, Your Honors. I've asked to reserve 4 minutes for rebuttal. May it please the court. TRIA, the statute at issue here, clearly and unequivocally waives the United States sovereign immunity. The statute only applies to blocked assets that are assets that have been seized or frozen by the United States. By its plain text, it applies in every case and notwithstanding any other provision of law. It very carefully limits the United States' ability to immunize a small category of property and only if certain requirements are met. Allowing the United States to invoke its own sovereign immunity to otherwise immunize assets would render the statute ineffective. In an attempt to avoid this absurd result, the United States has invented the possession versus no possession distinction and read it into the statute. As this argument goes, assets that are possessed by the United States are covered by sovereign immunity, whereas assets that are possessed by others are not. And this gives the statute independent meaning as far as the United States is concerned. The problem
That's because I think the writ of attachment has a different object, does it not? If it's possessed by the United States, the writ of attachment gets served on the United States. If it is, say, a bank is just, there's some funds that are frozen pursuant to executive order or regulation by the bank, and if you wanted to get a writ of attachment for those, would it not be that the bank would be the object of the writ of attachment?
There are certainly circumstances where other entities or people would ostensibly hold or possess the property that would be subject to a writ of attachment.
No, that's not what I'm asking, but I'm actually a more formal procedural question, and that is the person, the entity named in the writ of attachment on whom it is served and on whom it is operating, I assume would be the bank. In the second situation, I hypothesize not the United States government, even if it's a federal directive or regulation that has caused the asset to be frozen?
That is correct. In circumstances where a bank account is frozen, a bank account is held at Bank of America, for example, the writ would be served on Bank of America and not on the United States.
But it's not really all that fictional. I mean, that just is, if sovereign immunity applies when the government would be a defendant, not when it's not.
It's fictional insofar as the statute very clearly applies in circumstances where the United States possesses property. And I think it's important.
That doesn't that depend on whose property it is?
I'm sorry?
It depends on whose property it is.
It would need to be Iran's property, but in circumstances where the United States happens to possess that property, the statute very clearly applies.
Wait, maybe if the United States possesses that Iranian property.
Correct.
Okay, well, we don't know if it's Iranian property. There's an issue in the other proceeding.
That's correct. There is an open question as to whether this property is actually Iran's or not.
Why should we proceed with your?
For the purposes of this case, though, the United States has conceded that at the point when it took the property,
they can concede it, but that doesn't help them or help you. You're familiar with the Heiser case, right?
I am correct.
Okay, so let me just read one sentence. Whether plaintiffs can attach the contested accounts depends on whether those accounts are the, quote, property, close quote, or, quote, blocked assets, close quote, of Iran. Correct.
And when the United States seized these assets, there was no question that this was property of Iran. The United States has conceded that when
this is about whether you can attach them.
I'm sorry?
This is about whether you can attach, not whether the United States seized.
Well, the statute only applies to property that the United States has seized or frozen.
Oh, Iranian property that is just seized or frozen.
That's correct, Your Honor. And what I'm trying to say.
Why would we make an assumption, proceed on a case that could be an advisory opinion, when the matter is going to be resolved in the companion case?
It would not be proceeding on an assumption, Your Honor. When we submitted our initial application for the writs of attachment, we demonstrated satisfactory to Judge Lampart that these were Iranian assets. And when the United States moved to quash, they said, for purposes of this motion, we are going to agree that when we seized the property, when the United States seized the property, the Iranian government had an ownership interest in that property. And so we had no obligation at that point, I think, having already satisfied Judge Lampart that this was Iranian property when we made our initial motion, to then additionally prove an issue that was no longer in dispute. So it wouldn't be an advisory opinion. At this point in time, we've demonstrated that the property is Iranian.
You demonstrated that the United States didn't object to that assumption, right, at that time.
Well, the district court so ruled as well.
The district court so ruled, that's right. And the assumption is, and this is...
So ruled what?
Ruled that the property was Iranian, that there was an Iranian ownership interest in the property. Because when the property was seized, it was owned by the Islamic Revolutionary Guard Quds Force. And that was the basis of our initial motion.
Was that binding in the forfeiture proceeding?
The United States has alleged in the forfeiture proceeding that it was Iranian property. There's another party who's disputing that. But for our purposes, I think there is a judicial finding that this is Iranian property when it was seized, and that therefore the statute applies, but for the fact that the United States has claimed because it is in possession of the property, it's subject to the United States' own sovereign immunity. And
You don't think we should wait on the forfeiture action?
well, the problem is, Your Honor, is that
Because you have a notice of a right to intervene yourself and press these claims too.
excuse me, I'm sorry.
You have a notice of a right to intervene in that proceeding and press the claims?
Correct. And our claim would be much stronger in that proceeding if we go in there with the writs that we have, right? Because we would then have a property interest that would be different than just a general unsecured creditor. Now,
Well, if you intervene now, you will go in there with the writs in hand.
that's a step that has not been taken yet, given the posture of this case. One of the options that
You have the writs in hand, they've been issued.
we had the writs in hand, they were issued, they have now been quashed.
Right.
So one of the options that we had in the event that the court was to vacate the order quashing the writs would be to go back down. There might be some additional litigation that would need to happen in front of Judge Lampard, but then ultimately we do still have the option to go into the forfeiture action and seek to enforce the writs there. But I do want to return to this point about the United States.
One second. When you do that, it will still be the burden of the forfeiture court, for Judge Friedman to decide whether the assets are those of Iran or of Fujira, whoever the other party is.
Certainly, Judge Friedman would still be able to hear whatever evidence comes in and decide whether or not the property is Iranian. But again, as for the current posture of our case, we have established satisfactory to Judge Lampard that the property is Iranian, and that is an issue that the United States did not raise.
I understand that. I don't understand how it's going to help you in the forfeiture proceeding when the matter is going to be resolved de novo.
Because we would have our writs, and our writs create a property interest that's different than if we just went in there.
It's a property interest that's contingent on the outcome of the ownership dispute.
Of course, but it's still, in the event that we prevail and we prove up that these assets are in fact Iranian, having the writs would be very important because it would establish a concrete property interest different.
Are you a party in the forfeiture proceeding?
Not yet, but we had reached an agreement with the United States prior to their motion to quash, recognizing the importance of deciding whether or not the writs were validly issued, that our time to intervene and to file proofs of claim or notice of claim, I forget exactly what they're called, in the forfeiture action is being held in abeyance pending resolution of these issues. So while we have not yet intervened in the forfeiture action because we haven't needed to, we do still have the ability to do so in the event that the court vacates the decision quashing the writs.
If we were to grant your appeal, overturn the quashing of the writs, and in that way reinstate, in some sense, Judge Lambert's decision as to this being Iranian property, and if Judge Friedman were to decide it wasn't Iranian property, whose property decision controls?
It's important to understand the posture. We were at a very early stage here when the United States moved to quash. So there are additional issues that could be litigated. And I think if in that scenario, if we were to go in front of Judge Friedman and he held a trial or there was some additional record and he ultimately concluded that this was not Iranian property, then we would lose because under the HISAs.
Even if you win your case here and go in there with your writs of attachment revived.
Correct. I don't view a decision here vacating the motion to quash to be a judicial blessing, if you will, of the finding of the Iranian government that was necessary to issue the writs.
So if Judge Friedman's decision is going to control, then going in with writs based on a fact finding that I think Judge Ginsburg said is the best contingent, it essentially means they're Iranian unless Judge Friedman says otherwise. That's the most you'd be going in with. I'm not quite sure how you're better off going in with writs of attachment that really have no power. Their force is going to depend entirely on what Judge Friedman says about them being Iranian property or not.
Because under forfeiture law, and we have responses to this, so I don't want this to be viewed as any concession. Under forfeiture law, ordinarily, a general unsecured creditor does not have standing to contest forfeiture as an innocent owner or otherwise. So while we think that TRIA might address those issues, that's an open question that has not been resolved by certainly not by this court, by no appellate court that I'm aware of. And so going in there with the writs would give my client.
I guess what I'm trying to understand, and I'm not an expert in this area at all, is if you go in there with a writ that's predicated on this being a fact finding that this is a Iranian property, but knowing that as a matter of law, that fact finding will evaporate if Judge Friedman decides the other way, then with that evaporation will go your writ, and you'll still be standing there as a general unsecured creditor. Because your writ is predicated on a factual error that you have conceded will be overridden by Judge Friedman's decision. So I'm not sure how it gets you in any better position.
In your scenario, Your Honor, it doesn't matter. I want you to think of a different scenario.
Mm-hmm.
You vacate Judge Lampert's decision quashing, so we go in with the writs, and then we prove up that this is Iranian property. We have now established that this is Iranian property, and therefore it's subject to TRIA, and we have the writs. So we can establish that we are not simply general unsecured creditors. We have a concrete property interest. Now, in a scenario where you vacate, we go back down, we go in front of Judge Friedman because our time to do so has not expired. He could say, well, I don't really care if this is Iranian property or not. You're a general unsecured creditor. You don't have standing to challenge forfeiture, so we're going to dismiss your
Wait, but
claims
Judge
out of
Friedman
hand.
will have long since granted you intervention already.
I'm sorry?
Judge Friedman will have already granted you intervention, which makes you a party, and your standing won't evaporate upon his decision on the merits.
There's no guarantee that you would grant us the intervention motion. One of the objections might be you should not allow them to intervene because they are general unsecured creditors, and therefore they don't have standing to challenge forfeiture. And so having the writs is essentially a ticket into the forfeiture action, one of a few different tickets that I think we would want.
If the government were to agree not to oppose your intervention motion and forfeiture action, would that take care of the issue?
I don't think so, Your Honor, because it's at least partially an Article 3 standing question. So I don't know that they can concede that we have standing in the forfeiture action. So I wouldn't be prepared to rest on that, even if they were willing to.
But your standing could also rest, at least you have an argument that your standing would rest on TRIA alone.
If you affirm Judge Lampard, we would go in and say that the general unsecured creditor general rule
You're
falls
not
to
general,
TRIA.
right?
But again, having the writ would allow us to avoid that. And I do just want to.
Should the district court have addressed sovereign immunity before this forfeiture argument issue was dealt with?
Which district court?
Friedman.
The proceedings weren't in front of Judge Friedman.
Okay.
We had a case that was long pending in front of Judge Lampard, and so Judge Lampard was the judge who issued the writs, and the United States intervened and moved to quash him there. So again, in discussion with the United States, we decided that it made more sense from a judicial resources standpoint to allow Judge Lampard to decide the underlying validity of the writs, at least insofar as the United States sovereign immunity is concerned. And that was a gating issue that we wanted to address first. And that is certainly a jurisdictional question and one that, would.
Well, in terms of judicial economy, you're asking us to decide a series of questions, none of which will matter if it's not Iranian property.
I don't necessarily disagree with that, Your Honor, but I think in any instance where you have a final decision, that is true, right? If you vacate a decision granting a motion for summary judgment, you don't know whether the plaintiffs will be able to prove out their case when it goes back down, but still that's something that's done all the time. And I view this as somewhat similar to that, in the sense of there was a gating jurisdictional challenge raised to the validity of the writs, and because of that, we're here. And so I think it would be an odd result, respectfully, if because there are additional questions that need to be resolved, we somehow lose this appeal just because Judge Lampard decided that the sovereign immunity applied, which is obviously a decision that we disagree with.
Do you know what the time frame is for Judge Friedman to act on this sort of basic question, to whatever briefing and maybe fact
I do not, Your Honor. Government certainly might have more insight into that. All I can say is we certainly monitor that docket, and there's been no activity. So I don't even know if this party who has come in to challenge the Iranian government's ownership is still, if they're still litigating their case or not. And certainly.
And is this other party claiming that they own the oil? Is that what's going on? Was it totally clear from the briefing? You don't know that either.
I don't know for sure. They certainly claim that it's not Iranian ownership, whether they're the charter or the actual owner or what interest they're claiming. I admittedly don't know that off the top of
Any other questions?
I thought you implied earlier that there was a deadline for your intervention.
I'm sorry.
I thought you said earlier or implied there was a deadline for your intervention in the forfeiture court.
There is, and if you bear with me, I can direct you to where it is in the record. I believe under the rules applicable to forfeiture, the United States has the ability to grant extensions of the time to file a notice of claim or an answer. And so if you look at JA 233, that's the notice that the United States filed extending our claim deadline. That goes on to 234. At JA 236, Judge Friedman entered a minute order requesting some additional information. And then JA 238 to 239 is the United States response. And then after that response, there was no further inquiry from Judge Friedman.
Just a little bit about your argument on sovereign immunity. It needs to be unequivocally expressed.
That's correct. It does need to be unequivocally expressed. And what I was trying to say before is, with respect to the possession, no possession issue, I think it's important to understand how TRIA works. TRIA says that blocked assets shall be subject to execution, and blocked assets are defined as any asset seized or frozen by the United States. So if you just take even just that first piece, an asset that has been seized by the United States shall be subject to execution, that clearly and unequivocally applies to assets that are within the United States possession. And so I think when you layer that on top of all of the other arguments we've made in our papers, arguments about the pervasive federal regulations that apply to assets that have been frozen, the arguments with respect to the language in TRIA, it applies in every case. It applies notwithstanding any other provision of law. All of those provisions make clear and unequivocal the Congress's decision to waive the United States sovereign immunity, which under Supreme Court precedent does not need to use any particular types of magic words.
I don't think it's quite that clear. You put it this way: if this is 201A, right, TRIA, if that is a waiver of sovereign immunity, I'm looking for what possible function can be left for 201B2, I think it is.
So I think the way this statute works is that 201A establishes the scenarios where the property is subject to attachment. And that would clearly include situations where the United States is in possession of Iranian property. The way the statute then works is it says, except as provided in subsection B, which is then the presidential waiver provision of the statute, which we rely on. Clearly, the United States has the ability, I'm sorry.
B doesn't apply in the exception area, B2.
There's the general rule, the property is subject to execution. B1 is the waiver. If these requirements are satisfied, the president has the authority in that scenario to protect or immunize property. B2 is the exception to the exception. So even if B1 is met, if B2 is met, the president cannot waive. And again, this clearly applies to property that the United States possesses.
I see your point. Yeah. So let's go back to A for a moment. We have this question of what is a provision of law, right? And there's a First Circuit case, I think it is, that says, well, provision of law is flexible enough to include a common law doctrine, something other than an actual provision of law statute. And I think a couple of cases the other way on that. But in any event, the dictionary definitions from the founding to the present would suggest that we're talking about statutory provision. Right?
I think that's not respectfully the conclusion that this court reached in the King case. In that scenario,
which case?
The King versus Doyle case. In that scenario, there was an identical. It was a a claim against, there was a time limit. You need to bring a claim within a certain period of time. And it said, notwithstanding any provision of law, you need to bring this claim within, 30 days, 90 days. The plaintiff or the petitioner in that case brought the claim within 31 days and argued that equitable enlargement should be applicable here. And this court, relying on the notwithstanding clause, said no. Congress, in clear language, made it clear that this statute applied notwithstanding any other doctrine, including the doctrine of equitable enlargement.
Well, so you just slipped from provision, or we did, you're saying from provision to doctrine.
I'm sorry?
We elided from provision to doctrine, you're saying in that case?
In that case, I can give you the exact quote because I don't want to.
Notwithstanding any other provision of law, blah, 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 530 days, relying on the clear and emphatic language in the statute. This is your brief, right?
Correct.
The court held that the litigant could not seek equitable enlargement of the limitations period because Congress left no doubt as to the mandatory nature of the time limit.
Correct.
It didn't. So, okay. So you're saying it's your addition to that, not disputing it, that they said that with regard to something which was not a statutory provision.
Equitable enlargement is a common law doctrine, just as sovereign immunity is. It's not a statutory provision. This court held that the language was clear and emphatic. There are other cases. The Bennett case out of the Ninth Circuit relied on the notwithstanding clause to override the bank check presumption of separateness. Again, not a statute that provides for that, a common law doctrine. There are others that we cited in our papers, and I would argue that
notwithstanding any other provision of law, definitely can't apply to the Constitution, right? A statute can't override the Constitution. The statute cannot override the Constitution.
A statute certainly cannot override the Constitution.
And if there were decisions from this court recognizing that sovereign immunity principles and our very strict rules of statutory construction are rooted in the separation of powers under the Constitution, then the notwithstanding clause would not override those.
If I'm going to put it this way, because I'm not familiar with the cases that you're talking about. If sovereign immunity was part of the Constitution,
rooted in the
inviolable, a part of the Constitution, then a statute cannot.
I don't know what you mean by inviolable, but if the judicial doctrines requiring very clear statements, sovereign immunity and judicial, which are meant to ensure that only the political branches waive sovereign immunity and not the courts, if those are rooted in separation of powers, then the notwithstanding provision can't override that doctrine, even though it's not statutory.
Well, if I could revise my prior answer, I mean, certainly, regardless of the source of the United States sovereign immunity, it is subject to being overridden by statute. That happens all the time.
Of course. What I'm saying is, sorry, I was trying to be more careful here, and I guess I wasn't. And that is this sovereign immunity principle, this maxim of requiring very clear and direct language in a statute. Right? Courts have said that. It's not in the text of the Constitution. But if courts have said that demand that there be such explicit and unquestionably clear waiver of sovereign immunity applied by courts is itself rooted in the separation of powers of the Constitution. And so the decision whether sovereign immunity is waived or not in a statute the analysis of that has constitutional roots. So it's more complicated than this. That's why I'm asking the question.
I understand your question.
If that's the point, then it does. Is that still? Can those principles be overridden by a notwithstanding clause like this?
I apologize. I misunderstood.
No, I wasn't saying it clearly.
We are not challenging that the waiver of sovereign immunity needs to be clear and whatever, I forget the exact phrasing, clear and unequivocal. Our position is that TRIA is clear and unequivocal. And so we're not relying on the notwithstanding clause or the other two provisions that we rely on. in order to say, well, you don't need to find clear and unequivocal language because we have the notwithstanding clause. Our position is the notwithstanding clause coupled with the definition, coupled with the presidential waiver is clear and emphatic. And so I don't think Your Honor's question.
But it's more than, we don't have principles like that. You have cases that you've found, which are helpful to think about, where common law principles or non-statutory principles have been held to be overridden by these clauses. But we're talking about something that's in a sort of a different league here, are we not? Because of the constitutional implications of it?
I respectfully don't agree with that. I think certainly the issue in front of Judge Lampard and the way that this has been briefed is the notwithstanding clause can't waive sovereign immunity because provision of law should be read.
Well, that's what he said, but that doesn't mean we have to say that's
certainly.
right to,
But I think if provision of law is read the way this court read it in King to include common law doctrines, then that is clear and emphatic language that it applies to all common law doctrines, including the United States sovereign immunity.
The government had as an alternative argument about the license being an exception to TRIA. Do you have any comments there?
Yeah, this certainly gets into the weeds of TRIA. I really don't fundamentally agree with the United States position. TRIA is very clear. There is a definition of blocked assets followed by an exception, and then within the exception, again, is a carve-out. So the definition of blocked assets applies here. It's an asset that has been seized or frozen by the United States. The exception is certain licenses, and I want to get the language here correct, needs to be subject to a license issued by the United States government for final payment, etc., in connection with the transaction for which the issuance of such license has been specifically required by a statute other than the International Emergency Economic Powers Act, IEPA. So what we have here is a situation where the property has been seized or frozen by the United States. It is subject to a license. The license that was in front of Judge Lampard has since expired. So it's, at least as far as the record that was in front of Judge Lampard is concerned, there is no longer a valid license. And that license was not specifically required by a statute other than IEPA, meaning the actual exception does not apply. So even though it's subject to a license, it is still considered a blocked asset under the threshold definition because the license was not required by a statute other than IEPA. It was required by IEPA and then a whole host of regulations and executive orders. I hope that answered Your Honor's question.
Yes.
Any other questions?
Yeah, I want to go back to King versus Dole for a minute. I'm not sure I understand now that I've looked at it more, what you're saying about it. If I understand it correctly, the court held that the statutory time limit for filing suit could not be extended through a judge-made doctrine, right?
That's correct.
Okay, so that was to say the statute, as understandable, simply says that the statute takes precedence over a judge-made doctrine. What does that tell us at all about the current case?
The statute took precedence over the common law
judge-made
doctrine because the time limit in the statute applied notwithstanding any other provision of law. So absent that language, equitable enlargement would have been available to the plaintiff, the same as it is in any number of cases. But because Congress made that time limit superior, notwithstanding any other provision of law, it did not apply. And so here, TRIA applies, notwithstanding any other provision of law, which would include common law doctrines.
Right, so you're saying the doctrine of equitable enlargement, you're analogizing to the judicial recognition of sovereign immunity.
Correct.
But sovereign immunity doesn't depend upon judicial recognition.
It's a common law doctrine, same as equitable enlargement. It's not found in a statute. And the The nub of this case, really, in front of Judge Lampart, was over the definition of provision. Is provision broad enough to include common law doctrines? The answer is yes. We would have our clear and unequivocal waiver of sovereign immunity, in addition to the other arguments that we've made. If the answer is no, then you would need to address the two other arguments that we've made, which Judge Lampart did not address in his decision.
It's still a bit more complicated because the Constitution does say which branches get to decide whether money comes out of the Treasury or property owned, held by the United States comes out of its hands. And the one branch that doesn't get to do that is the courts, right, in that first instance. And so it feels to me that this doctrine is not on the same level as equitable enlargement.
I think this court certainly has the constitutional authority, obligation to decide what a statute means, and that's what we're asking the court to do. And we would say that given the fact that so much of the United States position rests on the fact that the statute does not apply when we possess property that's owned by Iran. It only applies when other people possess property that's owned by Iran. And the definition clearly shows that that's not true. The United States, it applies when the United States has seized property. Clearly, the United States has seized, is in possession of property that it has seized, and under the statute, that property shall be subject to execution.
Well, frozen, it wouldn't apply to the frozen part of the statute. That's their view. And seized is not defined in the statute. And you're also in a world where you're going to be incorporating a lot of state law processes for these writs. So isn't that at least some ambiguity as to what happened here?
I don't see in Your Honor's hypothetical any ambiguity in the seized portion of it. Certainly the United States has never proffered a definition. I am aware of no definition of assets seized by the United States that would somehow apply to assets that the United States does not possess. I disagree that there's any basis.
Then again, I'm sorry. This is not my expertise at all. Is it formally seized that is possessed by the United States until Judge Friedman says it's Iranian? Or is it kind of a escrow-like holding until, strip away any technicalities of escrow, but is it sort of a in limbo holding or tentative holding until Judge Friedman says this was Iranian under this statute? It sounds like it can't be formally seized and possessed unless we know it's from a terrorist party.
Well, I don't know, and you're right. Seized is not defined in the statute. I don't necessarily know that Congress intended seized in TRIA to be wholly subsumed within a seizure for purposes of civil forfeiture. The executive branch, I think, clearly under IEPA has the authority to seize property even in situations where the United States might not be seeking formal forfeiture of it. And I think any dictionary definition of seizure would require the United States to take possession of the property. And there's certainly...
It's just there's a lot of seizures, and then, we hear about them nowadays with respect to Russian property of individual Russians that are seized, but then there's whole proceedings that come after them that I think are to sort of definitively determine whether they're going to belong to the U.S. or not.
I believe under IEPA, and this certainly happens in the frozen asset context, which I'm certainly more familiar with. In the seizure context, I believe under IEPA, the United States does have the ability to indefinitely withhold or indefinitely seize property. But even assuming that is wrong, which
without a court proceeding,
incorrect. Assuming that's wrong.
Seizure's an action. You can't indefinitely seize.
Respectfully, I don't know if that's true under the very
maybe as some peculiar statutory concept it is, but ordinarily, right, a seizure is an event.
With respect to the freezing of assets have been frozen indefinitely for decades. Right. I don't know that
blocked. They're frozen or blocked or what have you after they were seized. Right.
Correct. I don't think, though, even assuming I'm wrong, and let's say if the United States under IEPA, if they seize an asset, which would bring it within the ambit of TRIA, even if the United States then has some clock that starts where they need to judicially recognize the seizure such that it becomes the United States property. During the period of time when that clock is running, the property would be subject to TRIA, and our clients like mine would be able to come in and try to judicially.
But that may be the point then, is that
there would be no point to the statute if the seizure in and of itself made the property no longer Iranian. Exactly.
or well, that it gives you at least the standing to go into the forfeiture action.
I'm sorry?
That it's seeking the writ at least gives you the standing to go into the forfeiture action.
Seeking the writ gives us an additional argument for standing in the forfeiture act. Correct.
I'm still not satisfied about this King case because your analogy, I think falters because the court there didn't talk about the meaning of provision of law at all, and the case would be exactly the same, even if it had not been no provision of law or any provision of law notwithstanding had not been in the background, right? The court basically just said 30 days means 30 days. You don't need a notwithstanding clause.
In a scenario where the statute did not include the notwithstanding clause, the court certainly could have looked at it and said, for whatever reason, we don't believe that we believe this 30 days is mandatory. It's not subject to equitable enlargement. What the court in King did do was it looked at the notwithstanding clause and it said, we reach our conclusion based on the clear and emphatic language of the statutory provision at issue. It then goes on to talk about some other comparable statutes that did not include the notwithstanding clause and held that, I believe it was saying in those cases, equitable enlargement was permitted. And what the court said there, and this is on, looking for it, page 277 of the decision, comparing the two statutes, where the language of the provisions is as dramatically different as in these two statutes, we are duty-bound to examine the plain meaning of each separately, as is evidenced by the different periods of time for seeking judicial review that Congress enacted. Congress never intended that these statutes be identical in all procedural respects. So again, relying on the fact that this statute, the plain meaning of the statute that was actually before it contained the notwithstanding clause, it treated that statute differently than the other statutes. And so in a counterfactual world where this statute did not include that clause, the court could have rested its decision on other grounds, but it rested its decision on the notwithstanding clause in this case.
Would have. Yeah, I see your point. I don't think that the case nails it down. It's your application of the case that I think is not compelled. I understand it. It's just I don't think it's compelled by what's in the case. But I'll take another look at what you just.
I'm sorry, you don't think what's compelled?
Your conclusion. But I will look again at 277 to see whether there's more that I.
If I may, just to respond very briefly to that, the sentence that we've been focusing on, we reach our conclusion based on the clear and emphatic language of the statutory provision at issue by providing that notwithstanding any other provision of law. And then it goes on to list 30 days. I don't think there's any reasonable reading of this case that would suggest that the court was not relying on the notwithstanding clause.
What have you said? Remind me about the doctrine, I guess we would say, of by which the first court takes possession of the issue.
Prior exclusive jurisdiction doctrine.
Right.
Yeah, I mean, I think there are a number of responses that we lay out in our brief. One, the doctrine has exclusively been applied in scenarios where different courts either.
That doesn't move me.
Fair enough. If you agree that the notwithstanding clause.
We refer to the individual judges of the district court routinely as a court. Sometimes the other, sometimes not. Sometimes treating the court as a body.
I certainly don't dispute that individual judges are referred to as a court. I think the issue is a concept of one district judge taking exclusive jurisdiction over property to the exclusion of other judges within the same district, where we think the doctrine kind of breaks apart. But fair enough, if Your Honor's not, move on.
But you have more than that. You have something.
I can move on. I think if the court agrees with me, with our position, that provision of law encompasses common law doctrines, which we obviously urge the court to do, prior exclusive jurisdiction doctrine would also be overridden by the TRIA notwithstanding clause. This does not have the same, I don't think, constitutional concerns that Your Honor raised. And then again, talking about the posture here, we have not actually sought to enforce our writs yet. We had decided to go through this gating question first, to resolve this gating question first. And I think there would be plenty of opportunities, if the court were to vacate Judge Lampart's decision and send this back down, where we could work out a scenario where we enforce our writs, short of vacating them now at this very early stage. We could go in front of Judge Friedman and ask Judge Friedman to enforce the writs, either by filing a notice of claim in the forfeiture action or by formally seeking to transfer the case to Judge Friedman. There's no need for the court to vacate our writs, cut them off entirely, and then have us start all over again, which raises a number of concerns in terms of our ability to fully get the benefit of the writs that we've gotten. So I don't think this is a scenario where the prior exclusive jurisdiction doctrine really is impacting Judge Friedman at all. And I think he would be the best person to say when his jurisdiction is impacted or not.
Judge Millett's laid out the effect earlier, where you're coming into court with a piece of paper that says that Iran owns the assets. It's determined by another court, and they're on a potentially collision course, which he says they don't have.
That determination certainly would not be binding on Judge Friedman. It was made ex parte in front of Judge Lampart.
And would Judge Friedman's position be binding on Judge Lambert?
Or be binding on you for purposes of your writs.
If Judge Friedman were to determine that the property was not Iranian,
yeah,
and
you want to persist, are you then in a position before Judge Lambert to prove the opposite?
Well, if we remained in front of Judge Lampart and Judge Friedman determined that the property was not Iranian or was not subject to forfeiture through some other means, I don't know that would necessarily bind us. But there has still been no attempt at this point in time by Judge Lampart to interfere with the property that is in front of Judge Friedman, other than to issue the writs. We haven't sought to enforce those writs.
But you're not sure that Judge Lambert would be bound by anything Judge Friedman has determined.
I'm sorry, I didn't hear
But I've understood. I'm sorry. If I understood you just said that Judge Lambert would not necessarily be bound by anything Judge Friedman determines.
Just as judges within the same court are not bound by a decision that might be.
So they are on a potential collision course.
They are on
and in the future we have two appeals coming up from divergent judgments.
They are on a potential collision course, but respectfully, that collision course has numerous off-ramps.
I understand that,
so,
I think the purpose of the doctrine of prior jurisdiction is exclusive jurisdiction is to avoid that possibility, right?
It's a rule of right and reason, and when the reason isn't applicable, the rule doesn't apply.
Well, you just said that we could have here two conflicting judgments from two different district judges, which is avoided under the rule.
What the rule prohibits is one court, or in this scenario, one judge, interfering with another judge's exclusive jurisdiction over the property. Unless and until Judge Lampart, at our insistence, attempts to enforce the writs that have been issued, there is no interference with Judge Friedman's property. So my point is that if we go back down, we would have multiple opportunities to figure out how the rest of the litigation will develop, at which point in time, if the United States believes that we are trying to inappropriately interfere with Judge Friedman's jurisdiction, could raise the prior exclusive jurisdiction doctrine at that point. There is no attempt yet to interfere with that property. And
I
so
thought you
there,
had agreed earlier that Judge Friedman's decision, which would be made on a full record, would control and would displace this ex parte determination by Judge Lamberth.
I believe in that hypothetical that we were talking about was a scenario where we go back down and went to Judge Friedman to enforce our writ.
So why would you want to go to Judge Friedman? If we rule for you, you're best to stay out. 'Cause if you go to Judge Friedman, then you're going to be stuck with his decision. Whereas if you stay out of that action, you're standing there
Well,
with your, in hand.
respectfully, we didn't do so well in front of Judge Lampard either, so I don't know that we would be.
You're not going to be anywhere. You're just going to stand there holding your writs. You don't have further litigation to do.
We need to enforce it. We need judicial enforcement of our writs. So we would need to go in front of either Judge Lampard or Judge Friedman. If
Does the law say which court you have to go to for enforcement when there's a pending forfeiture action?
I think there would eventually come a point in time during the enforcement of the writs where, in order to steer clear of the prior exclusive jurisdiction doctrine, assuming the notwithstanding clause doesn't override it, which we say it does, we would need to go to Judge Friedman to enforce the writs.
Really? Judge Lamberth issues writs of attachment, and you don't go to seek property? You go over to another court instead?
We could make a motion to transfer the case to Judge Friedman. This was done. There was a case a year or so ago. I believe it was the Owens case where, prior to the motion to quash being resolved, there was a decision to transfer the case to the judge who was overseeing the forfeiture action. And certainly if this panel were to, make it a requirement that we formally move to transfer the case to Judge Friedman in the event that there's a reversal, we would be open to that. We have no.
Sorry, I just want to be clear here. So your view is that at the end of the day, enforcement of this writ would have to be by Judge Friedman.
Assuming the notwithstanding clause does not override the prior exclusive jurisdiction doctrine, our position is that.
But then I thought you just said at some point you're going to have to go to Judge Friedman. But if your theory is that notwithstanding clause overrides that doctrine, then you would never have to go to Judge Friedman.
If the notwithstanding clause overrides the doctrine, we would not necessarily need to go to Judge Friedman.
Would you, not too many qualifiers in there. Is it your view that if your writs are reinstated here, you don't have to go to Judge Friedman at any point because the prior exclusive jurisdiction doctrine is going to be overridden by the notwithstanding clause. And so you've got your writs of attachment and you need nothing more other than to ask Judge Lamberth to enforce them.
As a legal matter, that is our position. As a practical matter, we are willing to go to Judge Friedman in order to preserve our writs. So if this panel were to make that a requirement.
Well, how could we make a requirement without ruling on your argument, which isn't briefed to us, that the notwithstanding clause does or does not override the prior jurisdiction argument?
Certainly has the option. Judge Lampard did not decide this question to vacate the specific question he did decide about sovereign immunity, and then have Judge Lampard decide whether the prior exclusive jurisdiction doctrine applies to other separately make the writs.
On what ground would we, if we say the notwithstanding clause is enough to override something constitutionally rooted like sovereign immunity, on what legal basis could we conclude at the same time that it doesn't override this prior jurisdiction argument? Is there any basis for doing that?
If that's the path the court takes, then I would agree that the prior exclusive jurisdiction doctrine would likewise be overridden.
So then we wouldn't have the ability to say, I guess we just could drop a footnote saying, no, but please just make our lives easier by going to Judge Friedman?
Fair enough. What I was referring to is obviously we rely on a few different provisions of TRIA. And so, there is a world where the court were to say, well, we're not going to reach the notwithstanding clause issue just yet because we think the definition of blocked assets is clear. And so then there would not be a finding as to the notwithstanding clause. And we would go back down, and that could be a question that would be open for Judge Lampard. And quite candidly, we might decide to move this issue to just request a transfer to Judge Friedman. We have no preference, for lack of a better word, over who ultimately decides whether the writ should be enforced. We just want the writs that we obtain to remain valid so that we can go and enforce them somewhere.
Well, could you just ask Judge Friedman, move this dispute without our decision to Judge Friedman and ask him in the forfeiture action to issue writs of attachment?
We theoretically could. There's a priority concern about that in the interim time between going to Judge Friedman, trying to get the writs reissued and reserved, that someone else could step in front of us. And so that would be a concern about doing that.
There's nothing to stop you from doing that today. Doesn't move this out, at least, right? Doesn't move this out until he actually were to act on it.
I'm sorry?
It wouldn't move this out until he would act on it, and I don't know how he could issue writs until he decides the property issues.
Writs are typically issued at a very early stage in the case, prior to the party who is then subject to the writs to raise whatever defenses they might have.
No, there might be. There
I don't
doesn't seem
think
much
you
of
would
anything
need to-
typical about this case.
I'm sorry?
Doesn't seem much of anything typical about this case. So.
I'm involved in a lot of these cases. There's really nothing typical in any of them.
Right.
And it's trying to, I'll leave it at that.
Right, well, no doubt for worthy clients. Any other questions? Thank you very much. We've kept you up a long time.
It please the court, Brian Hudak on behalf of the United States.
Do the plaintiffs need, I'm sorry, but I'm just trying to sort these things out from the start to the beginning.
The United States is an intervener below in the.
No, I got that much
Oh.
from your brief. Do the plaintiffs need a writ of attachment to be able to intervene in the forfeiture action before Judge Friedman?
So they do not need a writ of attachment to file a claim in the forfeiture proceeding. We would argue that to maintain their claim in the forfeiture proceeding, they have to have a specific property interest in the property sought to be forfeited. So if you're an unsecured creditor, you file a claim, you're going to be subject to dismissal on that claim because you do not have an identified property interest in the in rem property that is being sought to be forfeited. So without a writ of attachment under the law of this court, they would not have standing. It's a jurisdictional condition.
So you're saying they can file a motion that will be immediately dismissed. That's the most they can do.
That's correct.
And you don't believe that the Terrorism Risk Insurance Act gives them a statutory interest in the disposition of that property?
That's correct, Your Honor. And I just want to clear up perhaps some definitions of what is a block asset under TRIA, first of all. Under 201D2, it's not all property frozen or seized by the United States. It's very specific. It's property frozen or seized by the United States under Section 5B of the Trading with the Enemies Act. We can put that to the side. Currently, that act only applies to interests of Cuba. The other provision that it can be seized or frozen under for it to be a blocked asset is under Section 202 and 203 of the International Emergency Economic Powers Act, or IEPA. It's undisputed in this case that the funds and the cargo here were not seized under IEPA. The United States applied to a magistrate judge for a seizure warrant under the civil forfeiture statute and served that civil forfeiture seizure warrant on the operators of the Acolytes while it was in international waters. When it came, the only possible hook for this asset to be a frozen asset under IEPA is when it entered the territorial waters of the United States before the oil was pumped off in the U.S. Because IEPA only applies to property within the jurisdiction of the United States. And the way that that's been interpreted through executive orders and OFAC regulations is that the property has to either be in the hands of a U.S. person or it has to be in the United States. So the only time that IEPA applies to Iranian source or Iranian property is when it's actually in the United States or in the hands of U.S. persons.
Well, that would seem to apply to the bank account where the proceeds of the sale is.
Correct. And so you would have to find that the United States government is a U.S. person under IEPA for it to continue to be frozen. But let's assume that when they serve their writs of attachment, which was right around the time the U.S. was pumping off the oil after it identified it, after it rolled away, and worked.
I thought they didn't serve it till after it was sold. That was the agreement you had, wasn't it?
That was the agreement. They reached out to us right as we were pumping.
I understand, but they didn't serve them until it was sold.
That's correct.
Until it was money, property in the United States.
That's correct, Your Honor. But
okay, well, so why doesn't IEPA apply to that?
Because it's not frozen under IEPA because the United States had a license under IEPA to dispose of it. And so it wasn't frozen. And that's the holding of R.J. O'Brien. That's from other circuits, that's the holding of Holy Land. From the
what
Fifth
is
Circuit.
Its status then for purposes of the forfeiture action?
It is seized by the United States under forfeiture.
But it's seized but not frozen. I got that it's seized but not frozen. But why in IEPA doesn't? Too many acronyms here. IEPA does not apply to seized assets.
We didn't seize it under IEPA. The only provision of IEPA that allows for seizure of property is when the United States is in armed conflict with another nation. Under IEPA 1702C, when the United States is engaged in armed hostilities or has been attacked by a foreign country or foreign national to make confiscate any property. And that's the seizure part of IEPA that TRIA refers to. When it is seized under IEPA, the only time the United States seizes property under IEPA is when we're engaged in armed hostilities with another nation. Otherwise, you have to go through another process because due process concerns dictate that there be a judicial involvement in the seizure of property. And the civil forfeiture statute and its provisions regarding the ability for the United States to seize the assets of a terrorist organization or assets which afford a person a source of influence over a terrorist organization was the basis for the United States' seizure of this property.
So if it's going through the civil forfeiture action, right, these funds are going through that. Are they U.S. property yet or not?
They are in the possession of the United States government.
That's not what I asked.
I know
they say possession is 9/10 of the law, but I'm asking about the 1/10 here. And so, is it the property of the United States?
So, is it free and clear the property of the United States before a final order of forfeiture? No.
Is it burdened property of the United States, legally burdened property of the United States?
So, I mean, it's hard to answer that question with a straight yes or no. So let me do the best I can. The United States has a possessory property interest in the property once it is seized. The United States has a contingent future interest in the forfeiture of that property. Is it
a property interest or is it simply a legal claim to the property that you possess?
It's a property interest, as I understand the law, Your Honor, and it's a contingent property interest that springs into life once we have a final order of forfeiture, and it goes back to the date of when the unlawful act occurred that gave rise to
right. I mean, that's, but I guess I'm trying to figure out what the basis for a claim of sovereign immunity is if it's not something the United States owns now, it just has a legal claim to.
Sure. And I think the court addressed this question in the Calendar case where it said the sine qua non of the United States' sovereign immunity in the context of collection proceedings is when it has possession. There's a reason why when the United States takes possession of something, the laws are different. The United States has it, and this writ has been directed to the United States, not to a bank, not to a holder of the property. So
do you have the ability to turn it over if you don't yet? I mean, like, strip everything away. And so you guys have this nice bank account that you possess, at least, or that you have a hold of, but you don't yet know if it's your property. But it's in your possession, and they serve a writ of attachment on you. Do you even have the legal power to hand it over to someone at this point? Because it's not yet, you don't have title to it, it's not your property?
So this is the problem that raises the notwithstanding interpretation advanced by the claimants here. We have an order from Judge Friedman that the Marshal Service is directed to hold that property until he issues a final order.
Is it the Marshal Service that's holding that property right now?
Correct.
So you don't even hold it right now. You don't own it and you don't hold it.
The U.S. Attorney's Office doesn't hold it right now. The U.S. Marshal Service is part of the federal government, part of the Department of Justice. So the United States, a United States component of the federal government, holds it, and so sovereign immunity is at play. play.
So sovereign immunity is at play because I'm just asking the legal question: Could that writ even be responded to, in the sense that could the marshals, they have this interest that they have, this contingent interest, sufficient to allow them to even respond to a writ of attachment?
So this is where the notwithstanding clause, if there were multiple, and the Princess Lydia problem pops up, if there were multiple judges, even the same courthouse, issuing orders about what should and should not be done with a piece of property, then that's a real problem. We're under a court order from Judge Friedman in the forfeiture action that be maintained by the marshals.
Oh, right. That's what I'm trying to ask is exactly what that means.
Right.
Judge
So
Friedman order means that I assume it means that it couldn't be handed over. Now, you couldn't
we
hand
would
it
be
over.
violating Judge Friedman's order, Judge Lambert's order.
Would you also be violating federal law? Is there a statute or regulation that would be violating?
I think we would probably be violating I would have to look into it, Your Honor. I'm assuming there's a provision of 18 USC 983, which provides the procedures or federal rule, supplemental rule G to the federal rules of civil procedure, which governs civil forfeiture proceedings. That's not brief in this case,
Okay.
but certainly we would, if Judge Lambert directs us to turn the property over to the claimants, we would be in violation of Judge Friedman's order to hold it until he issues a final order in the forfeiture proceeding. And
That just seems different from saying you have a sovereign immunity defense to their action. I thought it would just be, what are you bothering us for? we don't have any authority to do anything with this property right now.
Well, but Your Honor, I think, again, the problem I'm addressing is the Princess Lydia problem. I kind of moved into there because you're going to have inconsistent judgments regarding the same piece of property. But at the end of the day, the property.
But I get the problem of inconsistent judgments,
Right.
but that doesn't show that that sovereign immunity is implicated because you don't own this thing. You just got the marshals following a court order here, but
Right.
it doesn't. Marshals follow court orders all the time. It doesn't mean anything they touch or are holding becomes United States property for purposes of sovereign immunity. I mean, courts order marshals to do things with property all the time. There's no sovereign immunity implications.
Right, but not a private party seeking to attach property that is in the possession of the United States. And I would refer the court to its calendar.
It sounds like it's in the possession of the court, not the United States. I mean, we're part of the United States, but this branch of the United States.
The U.S. Marshal Service is part of the Department of Justice and part of the executive branch of the United States.
I know, but it sounds like it's in the control of if anyone controls this property right now, it's the court. And the Marshal Service is simply acting at the behest of the court.
I would say that's correct. We're not going to be moving it anywhere out of the Marshal Service's custody absent a court order from Judge Friedman. But again, I would direct the court to the calendar case where there was a very similar factual pattern. The United States held money in escrow for potential other beneficiaries. And even in that case, this court said, no, you can't serve writs of attachment. You can't collect against the United States when it is holding property, even if it belongs to other people. In our brief, we go through
on sovereign immunity grounds.
On sovereign immunity grounds. We go through several of those cases in our brief, Your Honor, where, again, the sine qua non of the United States' sovereign immunity in collection proceedings is when it possesses the property. And that's the reason why we've articulated this distinction. Because the property here is not seized under IEPA, we don't have to concern ourselves with that portion of the statute. The only argument that they possibly get have under tree is that it's frozen. But the only time IEPA would have applied to this asset at all, the United States had a OFAC license in hand, authorizing it to seize, forfeit, and conduct the activities that it has been conducting with this tanker load of petroleum.
But they say it wasn't one of the OFAC licenses referenced in the TRIA statute.
It is, well, I think
at the time the license wasn't issued under one of the statutes referenced in TRIA. Is that correct?
Right. So I think the exception to the exception, as my friend put it, they're misreading it. The exception that he refers to, 201 D2B, applies when property continues to be frozen under IEPA, but there is another blocking regime that someone has obtained a license for. And so what it's saying is that this may still be covered under IEPA, but because you have this overlapping blocking regime and you've gotten a license there, that's going to be good enough to put it outside of the prospect of TRIA. It doesn't talk about when you have a license under IEPA at all. And the decisions from the sister circuits in Holy Land and in R.J. O'Brien say...
I'm sorry, I'm I'm being simple here, but if it was in,
So
the license doesn't take it out unless the license was specifically required by IEPA or the United Nations Participation Act or diplomatic relations.
right, so
None of those three applied here, right?
we believe that they do apply, and we briefed that.
Which one applied? Certainly not the diplomatic relations. I don't know what the United Nations Participation Act is, but I assume that didn't apply.
Well, if
Was this required? Was this license required by IEPA?
It's our position out of respect for our system. Again,
Was it? I'm just asking you a statutory question here, not
Yeah.
your positions and comedies and things like that. Was this license required by IEPA
this license in our mind was required by IEPA, yes.
in your mind?
It's the government's position that it was required by IEPA. That's what we got it from our sister agency, OFAC, to authorize the forfeiture activities of the United States and those working under its direction and control.
Okay, why was it required by IEPA for you to have this license?
Because then we would have had persons, including U.S. persons, making preparations for the offloading of the cargo and purchasing the cargo that are U.S. persons that would be engaging in property that is Iranian source petroleum, and that is blocked assets once they become into the possession of the United States.
So IEPA was definitely applied. IEPA definitely applied to this oil.
When it came into the U.S. territorial waters.
Right.
And that's the reason we got a license unblocking it and unfreezing it for purposes of our forfeiture proceeding. So the only time it could have been frozen, the United States had a license to dispose of it until it wasn't frozen. And again, I urge the court to read the analysis in R.J. O'Brien and Holy Land. But as far as the B exception here, the B exception here is not saying, well, licenses only under other statutes count. It's saying that even if the property remains frozen under IEPA, you don't have an IEPA license. If you have a license for another regulatory scheme that blocks assets, and you're acting pursuant to that, that's going to take it outside the coverage of TRIA too. So
Take it outside what?
outside the coverage of TRIA as well. So it's not that a IEPA license is insufficient to unfreeze an asset. It's saying that even if an asset remains frozen under IEPA, but unfrozen under an overlapping blocking regime, that's going to also take it outside of the province of TRIA. Because the whole purpose of TRIA is that it provides access to frozen or seized assets under IEPA, not unfrozen assets under IEPA, and not assets that have been unfrozen under other sources of law.
What, notwithstanding any other provision of law, is pretty broad, but it's not particularly ambiguous language. No other law can get in the way of this. Why shouldn't we just assume that Congress said what it meant and meant what it said?
Well, because I think if you look at the statutory backdrop, and we can get into that in a second, Your Honor, but also the words no other provision of law. Again, a provision.
Notwithstanding any other provision of law.
Right. And a provision of law is something that's written in a statute or regulation.
Common law is a provision of law. Is qualified immunity a provision of law under Section 1983?
I don't know, Your Honor.
Really?
Because
Is all the court decisions and putting meat on the bones of the Sherman Antitrust Act, are those common law, or the whole point is that they are brought into part of the statute?
And they're a source of law, Your Honor. I'm not debating their source of law, but whether they're a provision of law, it's an inexact phrase, even in the opinion cited by my friends on the other side. The First Circuit case that Judge Ginsburg referenced in the argument with my colleague, that was Brown against United Airlines. Even though there they found that the preemption language of the notwithstanding clause at issue there encompassed common law remedies, it said it's inexact, and we have to look through the entire statutory makeup to resolve the ambiguity.
Is the United States provision that the qualified immunity doctrine under Section 1983, which is there because Congress said we assume Congress carried this forward in the statute itself, because it was a common law backdrop. But that doesn't just mean we get to keep applying common law anytime we want. The whole theory for it is that the common law is brought into the statute, right? We're doing a form of statutory construction. That's what those decisions were. And so if we construe common law to be part of the statute, why doesn't that make it as much a provision of law as the rest of the statute?
in the specific context of Section 1983, it doesn't apply to the United States, so I want to be careful.
I know, but I'm just okay. We've got the Sherman Antitrust Act, same thing. There's plenty of time.
Well,
It's a general maxim that we assume Congress legislated against the backdrop of common law, and we don't do that to say so we get to rewrite the statute. We do it to say that's what the statute says and means.
Yes, Your Honor, and I think actually the Section 1983 is a good analogy here. 42 USC 1983 is undisputably a provision of law. It's written in a statute. The federal counterpart Bivens, is that a provision of law, or is that a judicial common law construct?
No, that one's not a statute. I mean, everyone knows that's not a statute. I mean, I don't think that's an interesting question, quite frankly, but what I'm asking you is a different one.
Sure.
And that is, I just don't understand this whole argument that we can somehow know when common law that's brought into a statute as part of it is a provision of that statute or not. That seems to me Federal Tort Claims Act, that's something you all deal with. And that incorporates, as a matter of statutory law, the state law of tort law, which is almost always common law of every state, or whichever state is implicated in the case. Are those tort law provisions not provisions? Is that incorporated tort law not a provision of federal law for purposes of that case? Well, this is the danger of this theory that we're trying to figure out. When common law is, when courts have said, I mean, their Congress said it in the Federal Tort Claims Act, but when courts have said, the common law is brought in as if written into the statute itself, then it seems a bit artificial to say, well, it's written in for purposes of us putting it there, but that it's still not a provision of law. That's the danger.
Right, but the common law, I mean, if you're going to say the sovereign immunity is part of common law, it's derived from common law, but I think it is elevated above concepts like equitable tolling and things like that we discussed in King.
Well, you didn't argue that in your brief. I've argued it, but you didn't argue it in your brief. You did not argue that sovereign immunity is constitutionally rooted.
Your Honor, we argue that it, unlike other common law doctrines, cannot be waived without a clear and unmistakable waiver.
But that was sort of just begging the question in the case.
And what all this discussion reveals is that there's ambiguity in the phrase notwithstanding any other provisional law. And as soon as the court finds it to be inexact or ambiguous, it means it's not a waiver, because waivers have to be clear and unmistakable. Any ambiguity needs to be construed in favor of the sovereign. And even if the court finds a waiver for property seized under IEBA, which is not this case, it still has to strictly construe that waiver only to that realm. It does not clearly and unmistakably waive the United States as sovereign.
Right, but that argument depends on your argument that common law is not a provision of law. That's all I'm saying.
Even if you think the best reading of the statute is that common law is a provision of law and you're going to resolve the ambiguity in that fashion, the fact that there is an ambiguity means there is no waiver when it comes to the issue of sovereign immunity. I'm happy to go through our alternative points, especially the Princess Lydia, but I think I mentioned that earlier. Unless the court has other questions, we ask that the judgment of the district court be affirmed.
Well, I do have a question.
Sure.
Remind me of a statute in which the Congress has said specifically, notwithstanding our sovereign immunity.
I'm trying to remember. I definitely have seen them in statutes notwithstanding the United States' sovereign immunity. The best one I could give is actually in this very construct, in this very subject matter area, 28 USC 1610G, the Foreign Sovereign Immunities Act. It has a specific phrase that says U.S. Sovereign immunity does not apply. And it does not apply to regulated property under IEBA that has been used for a commercial purpose in the United States of a foreign terrorist state. So the problem here is that this property wasn't used in the United States for commercial activity. That's why we're solely under TRIA and not the Foreign Sovereign Immunities Act. But there, it was in the express title of 1610G where it references that the United States sovereign immunity waived. That's very different than what we have in TRIA.
Let me you just pointed to this exception for property used for a commercial purpose, right? And where is that to be found? Is that in 201B?
No. So the reason that we're only dealing with TRIA here and not the Foreign Sovereign Immunities Act, which has some parallel and overlapping provisions, is because the hope to use the Foreign Sovereign Immunities Act to attach assets is that the property must be used for commercial activity in the United States or some commerciality. That's the reason you're not seeing an argument for attachment under the Foreign Sovereign Immunities Act in this case. You're only seeing TRIA because this is undisputed. This oil was never used for commercial activity in the United States. The only reason it happened to come to the United States is in the United States' territory because the United States was seeking to forfeit it.
This calendar case that you've talked about, is that in your brief?
Yes, Your Honor.
Where's that?
It's in our brief at pages 15 to 16.
For some reason, I didn't see it. Is that in the? I misspelled it. That's how you pronounce it, calendar. Okay.
I'm sorry.
Okay.
Calendar. I'm sorry.
Right. I thought you had a calendar like CALENDAR. Okay.
Yes, Your Honor. And again, I just note that one of the holdings of that case was the government need not have an actual interest in the funds in order to impose it.
That's right. And just one other question. If Congress passed a statute that said Party X may seek judicial process against the United States when it holds the property of Party Y, would that be a waiver of sovereign immunity?
I think it will be, Your Honor. Depending on the other circumstances of exactly what the language is in the statute.
Well, so we have a line in the statute that says a writ of attachment may issue against property of a terrorist seized by the United States. Why isn't that judicial process? Party X may seek judicial process against the United States when they hold property Y.
That's not the case, Your Honor, because the property wasn't seized under IEPA, and that's the only property.
So if this were seized under IEPA, then there is a waiver of sovereign immunity.
I think I don't want to plan on that because it very.
Well, you just said that language would be enough.
Again,
and that's exactly what the statute says.
On behalf of the United States, I cannot concede that point because it's not really presented in the issues before this court.
Well, it seems very much to be in their view. There's an argument here about the role of IEPA in this case, but if they're right that that TRIA applies to this asset, and that's something the district court didn't rule on, correct? Didn't rule on this whether it was a blocked asset or not.
It didn't rule on whether it was a blocked asset. Right. It assumed it was. But
okay, so I just want to be crystal clear here. If they're right that TRIA does apply here, then what is the argument that the language, and you have to knock out other language, but it doesn't seem to qualify a waiver of sovereign immunity that says a writ of attachment can be sought by them, judicial process can be sought by them against property that is held, seized or frozen, but seized is certainly held by the United States. Why is that not enough?
So one, there's no in this case that it was seized on the right, even below.
Again, I said if they're right, but go ahead.
Two,
if they're right that TRIA applies, that it's a blocked asset for purposes of TRIA.
Right.
I understand you have your arguments. I'm asking a different question. If we assume it's a blocked asset for purposes of TRIA Section A, why is that not a waiver of sovereign immunity? That you are subject to judicial process for holding it, when you hold it by a private party? Again,
given that that's not the facts presented, I think the government would have a much more difficult time coming before this court and saying that's not a waiver of sovereign immunity. Here, because it's not seized under IEPA, and the writ of attachment was issued.
Well, then how did the district court make its sovereign immunity decision without answering that question? It seems to me that question is indispensable to it, because if it is a blocked asset, then there is a waiver of sovereign immunity.
No, Your Honor, if it's seized under IEPA, again, not only does there have to be a waiver, the waiver has to be applicable to this case, because all waivers not only need to exist.
Did the district court say this was not seized under IEPA?
There's been no contention it's ever been seized under IEPA.
Did the district court say that because there's no waiver of sovereign immunity because this wasn't seized under IEPA?
That argument wasn't presented because the only argument that was presented was it's frozen under IEPA, not seized under IEPA, because the only provision of IEPA that allows for seizure is confiscation during war times. So it was never applicable. The district court didn't reach it because it was never argued.
So your whole argument is simply that that other verb frozen
Right.
is not a waiver of sovereign immunity, but the verb seize would be hard to argue that it isn't.
Yes, Your Honor, and the reason for frozen.
Why would Congress split the sovereign immunity atom that way in a single sentence?
Your Honor, I don't know, but what I would point to is the statutory backdrop of the congressional enactment since TRIA. Since TRIA, it provided 1610G in the context of a waiver of sovereign immunity for certain assets under the Foreign Sovereign Immunities Act. And most recently, it created the Terrorist Victim Compensation Fund. It seeded it with some money up front.
Well, that gives parties choices. I don't know how that answers a statutory question about a party that has chosen not to go through the compensation fund and instead to pursue relief litigation. That's a choice that they're given.
It would render dead letter the ongoing funding mechanism for the Terrorist Victim Compensation.
Why would it do that? Because that funding mechanism is fines and penalties. It's not seizure assets.
It's largely funded by the forfeiture activities under criminal and civil forfeiture of terrorism assets.
My understanding of the statute is that it's fines and penalties that go in. Is that wrong? So if you prevail in the forfeiture action, the money in this account is going into the victim compensation fund?
If it's determined by the Department of Justice component with that responsibility to be an asset to meet the statutory definition.
Well, that's what I'm asking you. I'm not sure it meets the statutory definition. Am I wrong? I thought it was penalties and fines.
I can't speak to that because it's not within the Department. It's not within the U.S. Attorney's Office to make that determination. Assets very much like this. What I can say is assets very much like this have been found by the Money Laundering and Asset Recovery section of the Department of Justice to be within the Victims Act in 75%.
Assets very much like this, for example, another
seizures of blocked funds that had an Iranian interest in them.
And those have gone to the victim compensation fund?
Yes, Your Honor.
Okay.
And again, 75% of that goes to the Victim Compensation Fund. If Congress had intended that the ongoing funding mechanism could be thwarted by individual creditors racing to the courthouse and attaching assets as soon as the United States filed a forfeiture complaint against them, that would.
Well, I think I'm not sure that argument works for you. It seems like it's a very complicated one that involves which things go into the compensation fund or not, because the compensation fund itself specifically left parties with this option. Use the fund, which so far hasn't been satisfying everybody's claims at all, or pursue litigation, which is itself a risky route to obtain compensation. But unless you're telling me that this asset, if it becomes I'm just going to call it the funds now in the bank account, if you win in the forfeiture action, that 75% of that is going into the compensation fund. Unless you can make that representation, I don't think it's fair to say that they're trying to end run anything. It's not clear that they are.
Again, I can't make the representation because I'm not the fact finder on that. But
it's not fair to say they're trying to end run anything unless we know that.
Your Honor, again, if Congress contemplated that terrorism assets the United States is seeking to forfeit would be subject to collection activities by independent terrorist victims,
that's what TRIA says.
It would be because Congress passed the Victims Act and the Compensation Fund after TRIA, much after TRIA.
It didn't overturn TRIA. Did the Victims Compensation Act say we're overturning TRIA?
No, Your Honor.
Congress thought they could both operate side by side.
Right.
I just think this argument isn't.
Well, but if Congress saw
right now
that the United States waived the sovereign immunity for anything it seized under forfeiture, and that was going to be the principal seeding for the ongoing purpose of the fund, that would seem very odd.
If your reading of how the Compensation Act fund is funded would include this asset.
Yes, Your Honor.
Any other questions? Thank you very much.
I appreciate it. Thank you, Your Honor.
Mr. Petrocelli, we will give you 3 minutes.
Thank you very much, Your Honor. I want to start off with the license that my friend referred to. I believe he said that the license unfroze the assets under IEPA. That language is not included anywhere in the license. The license authorizes certain transactions. It says the transactions described herein are hereby authorized. That's a far cry from saying something is no longer blocked. I don't think that the reading of the exception that my friend offered makes any sense whatsoever. Respectfully, the statute specifically says that a blocked asset is an asset seized or frozen by the United States under IEPA, but it doesn't include property that is subject to a license specifically required by a statute other than IEPA. The actual language would be rendered meaningless if any license somehow remove the property from the ambit of the statute. With respect to 1610G, the example that my friend gave of an instance where Congress did clearly and unequivocally waive sovereign immunity, what she fails to appreciate is that the statute operates in nearly the exact same way as TRIA. The difference is that TRIA only applies to property regulated by the United States, whereas Section 1610G applies more broadly to any property that is used for commercial activity, including property regulated by the United States. TRIA, referencing the same two statutes, says if this property is regulated and blocked, it shall be subject to execution and attachment. It functionally is identical. The only difference is that 1610G in its title says United States sovereign immunity inapplicable, which of course titles are not dispositive of how a statute works. It's the language. And I would submit to you that if you put them side by side, there is no functional difference between the two. With respect to equating the definition of seizure with confiscation, that has certainly never been briefed or decided. I don't have a position on it one way or the other, but I think what it makes crystal clear is that assuming the United States is right and TRIA applies to property that the United States has confiscated, it clearly applies to property that the United States possesses. And therefore, there must have been a waiver of sovereign immunity as to those assets, and there is no basis, none whatsoever, in the statute.
So are you arguing that frozen and seized mean the same thing?
I'm not arguing that frozen and seized mean the same thing, but I'm arguing that there's no basis in the statute to split, I think as Your Honor used it, applying TRIA to all seized assets and only some frozen assets. The language is any asset seized or frozen by the United States. I believe those two words, seized and frozen, rise and fall together. And seized clearly within possession of the United States, frozen should be interpreted the same way. With respect to the suggestion that we had never claimed that the property was seized under APA, I don't believe that to necessarily be true. I would refer Your Honors to the sealed supplemental appendix at JA 188, which is the application for a warrant to seize property. And IEPA is one of the statutes listed there. So it was not an issue that was really fully briefed in front of Judge Lampart. We never had to take a position one way or the other, to the best of my recollection. So I would just invite the court to look there. And unless there are any further questions, we would ask that the court vacate the decision below and remand for further proceedings.
Any questions? Great. Thank you very much. I appreciate the help of counsel with this case. It is submitted.